on this relatively hot day at the end of the academic year. Most of you know me. My name is Sunny Drew. It's a very great pleasure to introduce our speaker and the subject he'll speak on. Dr. Abhishek Singhvi has a very distinguished career which spans politics and law. He represents West Bengal in the Rajya Sabha, which is the upper house, as you know, of the Indian Parliament, as a Congress member. His PhD from Cambridge was on emergency powers, and since then he's lectured at, well, I was just going to say pretty much all the top universities in the world, because the list is far too long. He's a former High Commissioner to the UK.
Yeah, it's fine.
Oh, okay, okay. Well, that's the perils of researching on the internet. He's currently, but you perhaps stated, you perhaps had the pleasure of.
I was my connection with England is much older than my father. I was a student here for 7 years. I had postgrad PhD.
Yeah.
But then, of course, I visited interviews here from 91 to 98.
Okay. Always a great thing. Having had a brother who's very commissioner, always nice to go and visit the residences. So Dr. Singhvi is currently honorary adjunct professor at Jindal Global University, and we're also honoured to have with us today Professor Raj Kumar, Vice Chancellor and founding Dean of the Law School, who frankly has played such a large part in Jindal's extraordinary rise to excellence, which is frankly astounding, as well as Justice Michael Woods from the Supreme Court of Hawaii, who meekly describes himself as part of the entourage, which is ever, I'm sure, is an understatement. And Dr. Singhvi is also one of the senior advocates of the Supreme Court of India, and he was describing to me how he continues to balance this mix of law and politics. His subject today is a case in which he appeared last month, I think heard in the Supreme Court over 10 days, and it concerns legal recognition of same-sex established relationships. Now, I'm not going to trespass on Dr. Singhvi's description of the arguments, but in short, the petitioners who come from many states seek to build on the decriminalisation by the Supreme Court in June 2018 of same-sex relationships, and in so doing they rely on a number of constitutional rights: equality before the law, prohibition of discrimination, freedom of speech, and religion, and seeking amendments to a number of marriage acts, including the Special Marriage Act, which makes provision for marriage between people of different castes and religion. Notable for observers from here, the nature of the interventions by the government, arguing that this was an elitist concept which was sought to being advocated. If one thinks about the fact that the current population of India exceeds 1.4 million now, whether one argues over whether LGBTQ plus citizens are 2% or 10%, one is still talking about millions, tens of millions of people. And also notable, certainly from my perspective, was the intervention of the Bar Council, which perhaps we'll discuss later. But I'm only here as a warm-up act, so I'd invite you to welcome Dr. Singhvi.
Thank you, distinguished members, faculty, students, and of course, Raj and Michael. Although all the organizations in there. I think, first and foremost, let me congratulate Raj for expanding his university exponentially in Delhi, but also expanding his footprint globally. Everywhere you go, you find gender now. The flag is flying high. And I'm very glad that there was a nice article employment. About this theme lecture, let me start by saying that the very nature of the beast, same-sex marriage, evokes very extreme reactions. It evokes, in particular in India, in a diverse society like India, societies fear of the unknown, need progressives, recognition of an opportunity to reform, the liberals' desire for maximizing freedom, very majorly in our case, the judges' dilemma about the limits of judicial creativity, and of course the particular category of conservatives discussed that what considers unnecessarily revolutionary. So it's a very volatile cocktail. And into this volatile cocktail, the most powerful Supreme Court, apex court in terms of judicial review, by far and undoubtedly globally the most powerful Supreme Court, stepped into it willingly, and we are now awaiting reserve judgment. And should argue the fact one event is prevent that. As some of you know, perhaps that India will be perhaps only the 11th or the 12th nation to have recognized same-sex marriage. And many of the others who did, and we have a list of 11 others, were those where judicial affirmation was followed very shortly by legislative recognition or legislative passage of legislation which recognized it. In India, there's no question of legislative affirmation for in any way, because the opposition of the government, which in the principle is one in this case, is vehement. It's very, very energetic, in fact, very positive and very. So unless the court gives something, there's no question of the judgment being followed by legislation. And although I come to it later and also come to a very delightful connection with England, in this case, the principal issue was legally whether you can do judicial surgery. Are you involved in stitching a new garment with Denny's words, or Denny's words? Or is it just ironing out the creases? Because we were asking for judicial interpretation to subsume under the existing law the concept of same-sex marriage. Before I come to solve the nitty-gritty of the interesting intersection with England, let me give you a summary and some that after partly. The 9 or 10 building blocks are out of this from the British side, because obviously we're all waiting the judgment. So the first of these building blocks was to seek a constitutionally compliant interpretation to eliminate discrimination, as in predict, arising out of purely descriptive conditions and characteristics. Descriptive meaning characteristics of caste, of ethnicity, of national origin, etc., based upon involuntary events and not on characteristics acquired by choice. And this was, according to us in our submissions, a discriminatory exclusion because it relied principally on a descriptive condition, a sole descriptive condition for discrimination, and that was making sexual orientation the sole marker of identity for exclusion. And that was the beginning of the basis on which the case was put. And as some of you know, we have a very, very powerful Article 40 in the Indian Constitution, which has started with anti-discrimination 75 years ago was applied. A huge number of other numbers and nuances. But this time it was questioned to service as to whether you will have this exclusion based on the discrimination arising from that descriptive condition. The second related basis for the arguments were the immediately following two articles of the Constitution, which particularize some of the discriminatory practices in terms of gender and various other things, Article 15 in particular, which goes into a more particularized subset of 14. Our third building block and basis was to apply the old traditional doctrine of discrimination, which arises under Article 14, which is the original one with Article 14 started in 1950. And that is that you cannot create artificial classifications. You can have classifications, but the classification to be upheld as constitutionally valid must be a reasonable classification, B, it must have a rational and a clear nexus with the object sought to reaching. All the classification with that. And we say, this is not one such classification. This was applying the more traditional interpretation of Article 14. our next basis was that you are actually creating an unequal hierarchy. An unequal hierarchy where you are consigning same-sex couples to the category of outsiders, whereas their need for affirmation and protection of their intimate relationships cannot be hierarchical, put lower than that of heterosexual. So this was a short aspect baked on issues like dignity, right to life, and all that. A fifth building block was to evoke the right to free speech and expression, saying that this particular assertion was an assertion of the right to express ourselves fully and the freedom to express one's gender and sexual orientation was an intrinsic part of that right to free speech, which is a separate article of the Constitution and a separate important right. A sixth basis was, of course, to put it in Article 21. Freedom of speech, especially in 19. 21 is the right to life, again, very broad, very much invoked article, which have now a very long laundry list of rights. And here we invoked the right to dignity, the right to live with dignity, where the central importance of marriage as a social institution was presented as a core issue of dignity. And therefore, exclusionary paradigms based on sexual identity or gender identity would be contrary to that core concept of dignity, which was subsumed in the context of Article 21. A seventh basis was invoked on the basis of the right to privacy, a right which has been more recently sourced to the Constitution after many battles in a very large bench decision, so that privacy, while it further nuanced as to say that it is not that privacy is to be limited only to private spaces. It belongs to persons. The person carries that right, not only in the private space, and therefore it could apply to be exercised in public spaces also. There was another basis, a relating basis of decisional autonomy, which is again was a part of all these articles. Finally, there was the invocation of the doctrine of proportionality, which is a lot of significance in Indian constitutional law, which was another facet of Article 14. But all the usual tests of proportionality, not also the English law as much, without the Constitution, the nation did not write European rights treaties. Then it must disclose a legitimate state object. There must be a rational nexus. The necessity for the rights infringing measures should be least restricted. The need for balance between the state object and the extent and severity of the infringement, and the existence of sufficient safeguards in it. So this five mixed up principles or combined principles were applied for and to revoke the right to proportional action or proportionality. Now, with this basis, the case was opened, and the case and a lot of residents were very receptive range. The major dilemma, which the judges soon hit upon, and the major dilemma we knew before we started, was the fact that A, you were seeking all of this to be subsumed by entirely like judicial interpretation, subsumed under the existing law, no legislation. The government is against legislation, no new framework. So this was a bit of a leap of faith when we asked the judges to do that. The second, more particularly, was a seeming paradox, a seeming contradiction in our case. And the seeming paradox was that on the one hand, we could not and did not seek invalidation of the statute. The entire case was based, which I'll be coming to in a moment, on something called the Fisher Marriage Act. It's on their mention, The Special Marriage Act in India was created much after the Hindu law reforms and the personal law reforms to provide for a religion-neutral marriage of heterosexual couples, obviously intended heterosexual couples. And it is basically what we in India colloquially call registered marriage. So our whole case was based on the fact that in that act, you simply have to read a few words here and there as spouses or as persons in a sex-neutral manner, and therefore subsume same-sex marriage. So apart from the initial problem, the hesitation of being such a big thing, pure relationship interpretation, the second point, which was seen as a contradiction, was that why we could not seek invalidation of the SMA for not doing so, because if we sought that, we suicide and we would have no framework to apply to recognize same-sex itself. So on the one hand, we never sought invalidation of any statute, in particular, not of the SMA. On the other hand, we wanted a kneel up on a reading down of the SMA, which sometimes thought was a very opportunistic, self-serving approach to interpretation, to get our way to recognize same-sex. So there was that inherent problem, although I don't think it was such a major problem. That was the perception problem of the bench in the United States. Excuse me. Which brings me to what the judges themselves characterize as the Kenan moment, which is the remarkable, and I did not know the English connection here till I researched the topic, and the judges called it India's Kenan moment. It is a very remarkable paradox that a country which in that sense, India, is far, far ahead in judicial and constitutional dynamics, far ahead that had to make Marbury, Madison, Glass, it's on far ahead with all that. And in a constitutional matter, one of our principal reliances was for a country which had only interpretation. And now, even with the right treaties of Europe, limited to interpretation. So that was the very interesting anomaly which I found, especially among being a student. But I was struck, in particular, as being a student at Cambridge, at the revolution occurring in England on interpretation, which I discovered when I read Hannah. So let's turn to Vedan, which was the next major basis to meet the hostility of the bench. How can we do this interpretation, Dr. Singh? This is part one. So Vedan, there was a very interesting factual matrix. Landlord Vedan sued the chap on voting in this country, claimed possession of his flat, and voted in defense argued that I'm the main living partner of the deceased tenant, James, and therefore I'm entitled to succeed as the surviving spouse of James under your 77 UK rent. And there's an interesting para in that Act 2.2, which says, quote unquote, being a person who is living with the original tenant as his wife or husband, as his wife or husband, unquote. And the issue arose after the coming into force of the UK Human Rights Act, which has another phrase that says, real and give effect to legislation compatible with the convention, but then adds the caveat, as far as possible to do so. So it was in this context. Now, what the Vedan court did in England is what struck me as revolutionary by my standards as a student and in committee against that. Without taking much more time, just to summarize Vedan, and the House of Lords has various comparative chapters and all that. Firstly, they said very clearly, uncommonly clearly for a country which is nuanced in interpretation and hesitant to be seen as doing what was called that famous case, naked subversion of this, the rights and not winning. The first thing they said was excessive concentration on a literal or technical approach should be eschewed. And they said, quote, broad approach concentrating amongst other things in a purposive manner, a purposive way on the importance of the fundamental rights involved. That should be the approach. Second, they said that ambiguity in statutory language is not an essential prerequisite to adopt the purposive approach. Third, they said that these approaches, that is the Gedan approaches, are necessary. Quote, even if the statutory language is not capable of bearing two possible meanings. And lastly, and most importantly, they applied the conventional principles to say that the UK courts are empowered even to change the meaning of the legislation. They're not my words, these are words of the House of God, which is starship doing, but very useful for our argument, since we were actually operating in the realm of interpretation alone and not validity in India. And in the words of Lord Nicholas, I just will take 2 minutes to just quote it. He said, quote, it is also apt to require a court to reinvert first change the meaning of the enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting Section 3 was that to extend boundary only by what is possible, a court can modify the meaning and hence the effect of primary and secondary legislation. And then they came to something even more revolutionary, both by Indian and British standards. It's by only new forces, mixing up a different thing, but in a way, they propounded the basic structure theory within the realms of interpretation. As you know, the basic structure theory in India is entirely on the ability to keep. It's a marvelous, fantastic theory, which makes a permanent bulwark against dictatorship, constitutional dictatorship. In a sentence, says remarkably that even a constitutional amendment with all the two-thirds majority of the legislature, a constitutional amendment can be unconstitutional if it violates the basic features of constitutions. A lot of constitutional amendments say that the Republic of India is stated to a monarchy will be unconstitutional as violating the basic structure of the Indian Constitution. And the second thing it says is that what is part of the structure of the Indian Constitution and what is not a part will be decided on case-by-case basis. And therefore, the final arbiter of that would be the justice. So we have a very good and a strong list of such backup: democracy, rule of law, one man, one vote, free and fair elections. All these are in element part of this. Here I found that when the judges in the House of Lords use the phrase that decide what is possible by looking at, and I quote, and underlining, I quote, a fundamental feature of the legislation. And then a second phrase, the grail of the legislation. And the third phrase, the very core essence, width, and substance of the measure. That sounded to me very much like the validity concept of basic structure. And having come that far, the final principle of the same was that if you have jettisoned interpretation, you gone into purposes, you in fact change the meaning of the legislation, and you have changed it on the basis of the fundamental feature of the legislation, you will still pull back. And they put a circumscribing boundary by saying, if you are institutionally not equal, that is the final part of TEDA, which we should make to about. And the institutionally not equipped may that impose the TEDA judgment by the different laws, that either if it involves the substitution of a detailed statutory scheme, basically rewriting a statute and new scheme we create, or if a policy choice needs to be made between different methods, or would have far-reaching practical repercussions which a court will not control. It's pretty much the same approach, basically. God will too far, it's a matter of beginning. And the next part of our argument was, and that's a part of our present bill, that none of these circumscribing boundary principles rights for meaning same-sex marriage within the existing works of SN. Because they said, even if you apply the Gedan principle on pure interpretation basis, you will have limits, and you must cross those limits opposite. So, on that aspect, of course, we also went into global students recited roundly board, where it was commented down that the 14th Amendment favors did not specifically, did not ever intend to apply the another is tell me this. Ground report was has specifically said that we do not intend to apply desegregation from that amendment, and yet the board applied it because that it will not be actual intent. So we said that all this is possible within the SMA because 90% or 75% or 85% is reading a sex neutral interpretation in other words. The second problem was that we had to contend with the proliferation, with the varying diversity of personal laws in there, which is not true of many countries. So very early on the principle of the discretion of the better part of that, I had stated in the court that we are not asking to apply this interpretation to any personal law marriage. So our entire case is based on only SMA marriage. When India would have an SMA marriage, it would have, and it's already other past, majority of marriages are outside this. It's a non-registered marriage. So the marriage would be between Hindus and the Hindu law, between Muslims and the Muslim law, between Christian and the, whatever customary law, tribals, customary laws. So our case was this would apply only to those who chose to marry under the SMA. Obviously, if it is allowed, the same-sex couples will choose to marry under the SMA. That gives the facility being pregnant. But even there was a question that why all the other category, that is Muslim marrying Muslim, Christian marrying Christian, Muslim marrying Christian, Hindu marrying a Muslim, Hindu marrying a Christian, all the combination and combination would be covered under the neutral Indian Succession Act, because marriage has consequence of succession. The problem was that the Hindu marrying the Hindu would be covered by a statutory purification of personal law, the Hindu Succession Act. And that is one of the problem questions put to us by the bench, that we would actually be suggesting a SMA framework which would really ignore the Hindu marrying the Hindu choice in a personal law context. The other objection was that there are some permissions in all these acts, including the SMA, which talk of rape, sodomy, bestiality, etc., which you cannot read in a gender-neutral lab, because by definition they are gender. Our answer to these questions was that first of all, would be covering for the analogy of only the Hindu marrying the Hindu personal law category. You can either exclude it like excluding all other personal law items, or you can simply say that a Hindu marrying a Hindu would be treated as a marriage under the SMA, and therefore apply it. And for the peculiar examples of rape, sodomy, etc., our argument was that our entire legals was limited only to the discriminatory and not to what I call the heteronormative provisions, which are intended to protect women. So protective provisions for the female sex need not be touched and need not be taken, despite the language. So there was, of course, you can see, there is not that perfection and clarity of logic in this. There is some amount of, running with the head and thinking the hand. But it's pretty close to a situation where a solution is suggested and is workable by interpreting the special mandate above same-sex marriages. What the court will do is up for grabs. Everybody's waiting for that. As I said, more than above all of this is a very narrow and more appropriately and school of law. This is a legal lecture or a legal exposition. But what matters much more in this case is beyond the law. It is all those factors, including the Bar Council, she said. The whole country is divided, and judges need a lot of courage. Because I believe if the judges expand the law, develop the law, change the law, clearly no legislation in every jurisdiction also have much in this area. But they do it incrementally. I do the example of a rubber band. So they slowly, gently stretch the rubber band and sometimes stretch it to its breaking limit, very slowly. And they then test the waters. And then they see the ambience around them and the societal ambience for the stakeholders and non-stakeholders' reactions are either favorable or neutral or indifferent, but most importantly, they are virulently loud and aggressive. Then judges do back up. They also want to be seen as moving in the same direction as social mores. Why, of course, changing social mores themselves, not going far, far ahead. And that is the real challenge in this case. We were quite surprised at the vehemence of the response. The governmental response was understood, expected, anticipated, not at all surprising, although the vehemence even then was surprising. This particular government, and I'm not leading politics here, I know I've loved to be leading all of the shit back in that of the politics. This particular government has a very clear, strong view, and they had, in fact, vehemently opposed. In fact, the Congress also that as governments are more serious towards and opposed even decriminalizing consent with homosexual sex. Private homosexual and lesbian sex was criminal by a statutory provision in India, and that was challenged. And the decriminalization of that by striking down that was opposed vehemently by both the previous government and this government. This was a much bigger faith. This was a much bigger leap of faith and imagination to not expect that outpatient. But what was surprising was also the way lobbies were organized and marshaled, the way the press was segmented. And you had for almost a month, brought it clear that this case lasted in some places, an absolute carpet bombing of news, where, of course, I think the proponents on our side did lose out in terms of the ability to capture space, because they were all obviously individuals or NGOs or people like once the space by those who were opposing were more resourceful, more resource enriched, and of course with full government backing, in many of these oppositions were obviously supported by the government or instigated by the government, would capture a greater amount of space. So that's the dialectics which is going on, and it has been the a fairly divisive issue in civil society, amongst tribal gatherings in Delhi, in lecture halls, in universities, everywhere. So that is, I think, a real issue which the court has to understand. The court is acutely aware of this arrogance of the larger perspective. And if they overcome the legal basis, the supposed legal obstacles put against us, which according to me, we have given them sufficient solutions to overcome, they still have a much bigger mountain to cross, for which there are no solutions on this side of the bar. It really depends on your decision and, to some extent, the value judgment to take that key. I think that is what the science is. Thank you so much.
You're right, Max. Like to think you really feels that Beer One is hearing about an extremely important case for all sorts of reasons. I'm sure there'll be questions. I thought so, but that's all. Would you like to identify yourselves before you ask the question?
I'm Robert Widgeon, Professor Junior Rice Law, King's School, John. I've worked in this area since about 1985. Especially, I worked on the issue with, like, is that the correct pronunciation? Deadpan? But it's probably right, yeah. Versus Godin Mendoza case, and Carter versus Austria on the same time. But sorry for arriving late. I may have missed this part, but when I teach English Rights Act to my students, I tell them question number one is there a potential incompatibility with the convention right? And if there isn't, you can put your Human Rights Act in the drawer because it can't help you. So Section 3 on interpretation is only used after you identify this potential incompatibility with the European Convention right. So I would assume in the Indian context, if it's working the same way, you would have to find an incompatibility with the Indian Constitution, would you? Or is that not necessary for this interpretation?
Answer number one, that we have the additional advantage when arguing in India and citing the British case, which, by the way, we never do constitutional matters. Even British is so much more than private law for the interpretation, and that's why the British like this case. But when we do cite the case, we have the advantage that it's only persuasive by to making a fraud general principle and see whether they will apply. It's obviously not right yet. But the second, more particular, more or relevant answer to your question is yes. You need to first, everything is Gadam moment here much later. Everything has to start with the Indian Constitution. Is it constitutional compliant? Our whole case was based on the first principle, which is what you said, that we wanted a constitutionally compliant interpretation of Article 14, which is our mega article for anti-discrimination. But it has been nuanced and expanded to cover a lot of other areas other than just traditional discrimination, arbitrariness. Then in the 70s and 80s, procedural due process. And now more recently, full-blown substantive due process. I guess for a moment that's another very strange story there that the Indian Constitution would be framed. Face due process of laws, the original back in Article 31. And the one we gained constitutional drops in this to the US and make fact further. You said, well, and so do not ever put this same phrase. We had lots of different experiences in that phrase. And they picked up this phrase from Japanese constitution, accepting procedure, except by procedure at Poland's law. So that was traditionally not handled at all, but substantially. We have now come 5 phases now. Pure anti-discrimination, to plus arbitrariness, to plus procedural due process, and now the substantive, all under Article 14, full circle from the original framing. So, to come back to your question, you first start with showing or attempting to show that the exclusion of same-sex couples is not constitutionally compliant under Article 14, unless you are able to raise a case on that. There is no second step. And the basis of that, you're right, is the part you was I started that, not here, that the whole case is based on that this is a paradigm of exclusion, discriminatory exclusion, based on descriptive conditions. Descriptive conditions being involuntarily not acquired by choice conditions like sexual orientation or gender. And on that basis, you are denying the right to dignity, right to express oneself, follow a job, poverty, be seduction in marriage, and therefore discriminating between 2 categories of couples. That was the starting point. There were 9 building blocks which I advocated. And when you cross those, you come to the issue, which is the dilemma in this case, that look, so what? I need the opposite. Why didn't you get legislation from the court, from the legislature? Well, our answer is that we want you, the judges, to interpret the existing Special Marriage Act to include and subsume on the existing law without legislative intervention, same-sex marriage. So then the question of interpretation of those. How much can we interpret a pure legislation? And in that context, then ourselves.
I think sorry to interrupt, but I think what actually for what was alive for, but it was a deliberate decision not to say that the Special Marriage Act was incompatible. So not to start with that Section 4 question followed by the Section 3 in our term.
Exactly. Yes, right. What is not compliant is not the SMA. What is not compliant is the exclusion of recognition of marriages, generally of same-sex. By not reading just 2 or 3 sections of SMA, to say spouse or persons, and not in place of wife and husband. The word used up basically wife and husband. So the whole interpretation is you can read the word wife, but there are other parts of the app which create it properly, which is what they go to us.
Yeah, I could just go back to an interesting feature of then Court of Appeal versus House of Lords. Actually prefer the Court of Appeals approach because they read in specific words. I think the word was as if they were husband or wife.
A person who was living with the receipt tenant as his wife or husband.
Yeah, they from him read in as if they were because the opposite sex couple living together were not married either. They were in an as if situation. So they just used words that included a same sex couple. And I then published a comment in one law supporting the Court of Appeal decision. And I said, this depends on the wording, because there were, so you had this as it husband or wife formula. You had other acts of Parliament that said person of the opposite sex. And I made the argument that those ones would have to be amended. You could in the Section 3. And the House of Lords rejected that. But one of the Lords, like another Lewisham, Walker, Nichols, anyway, said the wording didn't matter. That would make it a semantic luxury.
Absolutely.
Yeah.
I'll find out.
So as far as a bit as to this, the wording has no effect on Section 3 at all. They can basically strike out any word they want. So anyways, that's just one aspect of that case. But in the Indian context, of course, the remedies are more powerful because the courts have to hesitate. Are we crossing the line? Are we rewriting legislation, etc.? Whereas the Indian court has the power of invalidation. It can just say, well,
this is the irony I underline, that India would never need to go to Vedanta, but in this case, we have this peculiarities of a constitutional issue, which ultimately had to stop at interpretation because we could not invalidate the SMA. So for interpretation, we needed the Vedanta 1-2. As far as I can understand, you teach subjects so you know more. I haven't read that personally, other law related to Vedanta, but it is possible for Vedanta, the House of Lords, to affirm the Court of Appeal. He went much further. Lord Nichols went much further. And he, in effect, said the words, as you said, will matter, which is revolutionary, I think, in an interpretation context.
The problem for you is that they did have an exception for a fundamental feature of the legislation or institutionally inappropriate. So if you got the same-sex marriage issue in 2004, they would have not allowed the fault. So the two issues are quite different. That was right to succeed to housing. And right to have it should not to us.
You know, they said to us that you are putting a landlord-tenant dispute or the landlord-prostitution interpretation. So we said it's not the factual context, it's the approach. See, luckily because Lord Nichols has put the approach on a very wide canvas. He's not limited to a landlord-tenant interpretation. You're right, this issue in England would not go the same way in a lot of other contexts. But it provided an interpretive blank to project to the Supreme Court that in a country of restrained and conservative interpretation, you have the standards. Let's see now what happens.
Thank you very much for your lecture. I really enjoyed. Sorry, can I just say to you all, my husband, as he knows, although I want to push back at you, although I find it very interesting, I've really struck how court-centric it is. And I'm Irish, as you might have from my accent, and the Indian institution adopts several Irish articles. And today we've got half Indian Prime Minister who is gay, and we've had a very conservative society for so long that has really evolved in recent times dramatically in social context. And we've voted for gay marriage and had since the 70s on socially divisive issues. And I have a lot of sympathy with the person who said litigation sounds like landlords and tenant disputes. It's a very socially divisive issue, and the judicialization of these issues leads to, it tends to email It's borne out by the fact that it doesn't necessarily reach any logical conclusion, leading to so many other externalities as to legislation or to implementation. But I just wanted to push back on that a little bit to ask you about your view on wholly judicializing such complex disputes when the results that come from these, and I've seen it's on and looking at afar, and I'm also actually American as well, and I know the power acted up as a gay marriage in the US and how far away citizens' families, for example, are as to these issues. So maybe just a bit more the limitations of lawyers litigating all of such questions.
Yeah. So you're now asking a question beyond just the case that should be narrow.
I'm sorry about
No, it's a very valid question. This issue is not actually limited to law at all. It's a much wider question. I think, first of all, I'm not speaking personally. I believe very much in that lawyers should not choose their clients, not just their clients. I'm not judgmental about this, but it's a special part of my purposes. But to answer a larger question, my own view is one that it is true that the ideal solution to such matters has to be legislation. There is no doubt about it. The whole debate starts precisely because there is a large growing population, a genuine problem, and a resolute and a obstinate and a strong view of the existing political system, not progress. Now, there is this contradiction. Number two, that is the story of the Indian Supreme Court. The Indian Supreme Court, if you leave aside this issue, which is a social issue, has been constantly pushing the boundaries of inclusion of concepts which are not there earlier. LGBTQ, equality of employment, the various 5 facets of Article 14 papers that were created. They are now known as substantive due process. The right to privacy. So if you just leave aside same-sex or apply, the job of a constitutional court, and if it is done in a very small subset only in response to the other side's apple. Otherwise, the entire case in India is based on constitutional principle. Discriminatory exclusion of one category of persons based on descriptive provisions is violative of the constitutional ethos of 14, 15, 19, and 21. That's the logic. Vedant comes in only as a response to the other side's case. That look, you are not striking down the SMA, so you're doing different cases. Tell us how you do it. So this is an integration. But therefore, we should consider that the Supreme Court in PIS, the Supreme Court in the basic structure theory, the Supreme Court at everyday social, economic issue, when the Supreme Court starts doing anti-corruption crusades, when the Supreme Court starts doing civic cleanliness and environmental sustainability campaigns, when the Supreme Court starts interpretation of articles which the founders never, they're involved, vigilant dead theory in India. The founders never thought of. So all of these are the dynamics of constitutional law in what is clearly the most activist judicial review court in the world. If that be so, and for that, trying to take 2 more cases, adultery and decriminalization. We had this famous in Papers 377, which criminalized Parajist bedroom consensual sex between 2 ways of 2 months. Decriminalize very truths. Now, the government continued. Forget this government. I would call this government more consistent because it is very right-wing. The previous government, which is not, which is supposed to be following it, would be not working. They opposed this vote. Now, what is to be done? Now, that's the difference with the Indian Supreme Court. And Supreme Court's the word over. They have sole organization. They have direct original jurisdiction. They have epistolary jurisdiction. So you come with agreements. I'm not talking of this case yet. I'm giving you examples to answer your point. You have problems where people are suffering. People are being punished. People are being persecuted or prosecuted. So you have to find a solution. And the court find the solution. So if they can do it, then this is not an issue where they cannot do it. It's a question of what I call vitamin G. how much guts do you have to cross a line? Is it crossing the Rubicon, or are you within the Rubicon or somewhere around the Rubicon? So, it's not such a outlandish concept. In the dynamics of the Indian Supreme Court, it would be outlandish. I would say 90% apex courts around the world, because they don't just have it. There's Indian Supreme Court. And yes, Ireland is, of course, our directive principle of state policy, entirely an Irish concept. Although we have interpreted it very differently in Punjab.
Abhishek, thank you so much for that really fascinating tour de force on your appearance in the court and taking the arguments further. I want to ask you that after the Supreme Court judgment on the decriminalization itself, wasn't this a natural corollary to that? In some ways, you have already recognized the right of individuals to express themselves and to live in society, and law has given complete sanctity to that process. And after that, and that is fully recognized now, after that, what is so radical and revolutionary about the idea of a marriage when it essentially provides a natural expression of one's own personal preference to have a social and legal recognition to something that is already legal?
Question, Raj. That came up in the arguments as well. So let me read it. There was a bit against.
Okay.
As a matter of fact, we are terrified that the judgment comes only to say that we recognize the right of cohabitation of same-sex couples. That would be a wonderful non-decision. Because cohabitation is in any case not illegal. The moment to decriminalized, anybody can cohabit with anybody that's heterosexual or homosexual. So the real issue here is that the very concept of marriage gives it dignity and recognition, is socially construct, in meaning, a status which is equal. When you go out, this is actually we give definitions. Why marriage as an institution by itself is different from cohabitation. So I want the status of being a couple, the same-sex couple, just like you want the status of being a heterosexual couple. And that is said. But much more than that, there arises issues of, I would categorize them in three categories. Daily irritants, insurance policy between same-sex people, adoption, succession. There's a whole plethora of consequential things which follow. Now, everything is denied to recognize mere cohabitation. As a matter of fact, mere cohabitation would be virtually a very clever fraud by the court upon us. It is already recognized the moment you decriminalize. If I live with you in a room, in a house, there's no problem anywhere, no law induction. So really what is wanted is A, the social recognition, the legal recognition of a social status. B, consequential things about civic life, admissions, forms, insurances, things. C, adoption and succession. These two are very important, the last two. Then, of course, there are ENS, they're very much more. Now, the ENF, the really nitty-gritty ones, will have to wait legislation. You cannot, do that. But at least the AV or the ABC are required from this judge.
Gotcha. Point.
Switching from strict legal analysis to politics or legal context. I think the also world record for slow progress from decriminalization of same-sex sexual activity to same-sex marriages held by France, 212 years between 1991 and 2013. England, Wales, it's 46 years, 1967 to 2015. I think the record for speed is South Africa, 8 years, from 1998 to 2006. So my first reaction to the case in the Supreme Court of India, putting all the legal arguments aside, was just the period of time since the decriminalization judgment, 5 years. It seems to me it's way too fast. I can see the Chief Justice would like to go that far, but well, does he have the votes? This question. And just to add one more thing, Supreme Court of India, if they went to Santa Claus, would be doing something the European Court of Human Rights is not willing to do. Most recently, in the case of Nidal and others versus Russia in January, what they said instead is that every governor in all the 46 governments in the Council of Europe must create a legal framework to say such stuff, although there's not a be called marriage. So was there any talk of that as an alternative to any of the parties to the litigation?
Civil ser-
Raise something else, civil union, civil partnership, membership partnership.
Yeah, civil union was mentioned in passing, and it was in principle post bias. Was it required a legislative framework in any case? And there's no way there any legislative framework is doesn't forecast any human trade. The civil unions are at an anathema to very legislation at and civil unions again was opposed on the separate ground that the very recognition of an institutional marriage is meaning equal to a heterosexual person claiming marriage is required. And we believe that's an important emotive and psychological and social status. These are two grounds of opposite saying. You are right, there have been only 11 countries which have had judicial interpretation inclusive of same-sex. I didn't know that time ago we need equalization. That's an interesting facet. They're pretty diverse: Austria, Brazil, Colombia, South Africa, Taiwan, USA, and Costa Rica, Ecuador, Mexico. So they first times very, as you said. But if and when any court recognizes same-sex marriage, they will still always be doing partially, because it will mean safe-sex marriage, the very marriage being a kind of big thing, and a few other rights. Much will be still left for legislation. That everybody agreed. We, the opposite side and others, because a lot of nitty-gritty will still required. That nobody is denying. It doesn't mean that some of the very special kind of rights which heterosexual couples act will automatically flow and the non-heterosexual. But the idea was that the minimalist movement in the right direction should not be merely a declaration saying, I recognize cohabiting same-sex couple. It should be something more than that. To be meaningful. Because it's not just an empty thing, it is that it is a recognition of marriage and B of some rights with.
And I want to respond to that politics part of it quickly. Yeah. One of the things about the Indian evolution is that even in the current, the Supreme Court judgment, before that, the Delhi High Court judgment was there. And that was, of course, opposed by, and there was a Supreme Court judgment which stayed that. So in some ways, the wider political context is that clearly there is a push to seek this particular Chief Justices and the court's, indulgence on this matter at a time, because as you know, the judges have set terms and so there is that context. So even if, and I hope this will succeed, but if it doesn't, then there is still an opportunity to push the boundaries once again with newer arguments made. So that could be part of that effort. And as far as the political response to it is concerned, on many matters in India, the judiciary has taken the lead and the legislature has come about much later. Sexual harassment is one very good example, long before, in fact, it took more than a decade for the legislature to even have meaningful intervention. Even now, it's still at a very evolutionary stage when Supreme Court took the lead.
In fact, just to add to that, it has taken the lead almost every day. Opposition and supported the status quo, opposition to a new point, in fact, it supported the status quo, is a normal reaction of most of. I won the right to fly the Indian flag case, the case of which is a university and is very kept up on the progress thing. 98 was it? It is the right to fly this flag, the Indian flag by the Indian, was opposed vehemently. Right? So there are innumerable, I've given many examples just after this, But the only difference here, to be big and devil's advocate, is that I don't think the conference started anticipating the willingness, degree, the quantum, and the sustained nature of the opposition. This is the peculiarity of this. In all other cases where the court has moved in advance of social mores, the opposition, it's been a debate. It's been not so vehement. And this time, the degree, I think, has been a frightening event for the court. And that, according to me, will be the only reason for our failure, if at all we fail.
That's my point.
Because I think the court wants very much to do it, but they are taken aback by the huge amount of opposition. That's going to be the challenge. Sorry, you're saying.
Would you say in your answer?
Richard Ashcroft, I have the honour of being dean of this law school. Very grateful for your lecture and your visit. Very honoured. I have a question about litigation strategy. So, in framing your arguments before the court and justices in framing their decision, will in part be thinking about the next case as well as the case in hand, and how you frame your arguments in order to say, well, don't worry, because we won't be going over there. We won't be back next year with a new claim over here, but also keeping your hand sufficiently free that some other future case you can see where you're going. I mean, maybe your clients rather than you as the advocate. But how does that play out in the practice of arguing before the court?
A very, very interesting, important question. One, it matters this kind, not so much important or so much of strategy and even take in every case that you do. But in a case of this nature, where the nature of the beast is such, it's very important. The principal overriding consideration is don't bite off more than you can chew. This is told to me by me to my clients, by the clients to the other. In this role, there are unlions. There are people saying, no, all or nothing, black or white. So you have to explain to them that don't. Second, discretion depends upon whether you're asking a very big fee. So you need to be careful as to how much they can more offer it. That is the animating principle. But there were two facets here which are very interesting in particularization of the question. One is, which I didn't speak about because was very much a part of some petition, which I have, was an invalidation of a separate part of the SLA. I didn't tell you about that because it is part of the statute, you give it up in the argument. The SLA has a set of sections starting 5, which provides for a notice of objection regime. So let's forget this same-sex. Pre-same-sex era in heterosexual marriages also. Where I marry a different faith person, heterosexually, I have to give a notice. Gives 30 days for people to object, and then it is solemnized. And there's a procedure about form and all that. The same would apply in case you were subsumed. So we said that, look, in any case that must be struck down because already, for heterosexual marriages, it is creating a lot of problems leading to why it is actually having the effect opposite of what was intended. It is having disgruntled parents attacking children that 1 month. It is having, outsiders having a radical view of a particular faith, saying why that is this faith marrying another faith. And you're having, in fact, murders and kidnappings in that 1 month. So it is having an opposite effect, can't be. And they ended us. But then, to lessen the load, they said, this is a matter of making them need to be decided by the 5-judge court. It's a constitutional issue. It will be decided when the judgment comes about the individual constitutional validity of these steps. So that they kind of decide. The second thing which we had to, as a discretion matter issue, set aside is personal laws. See, personal law is a thicket which if you had embarked upon, this would be a non-starter case. You don't know enough about India to understand this whole thicket of personal laws. It's a very complicated thing. But in a nutshell, we have, barring the statutory codification for Hindus, for most faiths, we have personal laws. So a personal law governs, which is not statutory, or occasionally a personal law is codified in some smaller statutes. Now, theoretically, you are allowing by this judicial interpretation a violation of that personal law. So, for example, the personal law of Muslims does not recognize it in blood. How the hell can she, a judge, tell me, a Muslim, that same-sex marriage is permissible? So the answer to that is that we are only limiting ourselves to SMA, which in any case is designed to allow a Hindu and a Muslim to marry, to allow a Christian and a Hindu to marry. But the moment you say your interpretation should apply to all faiths in India who are marrying outside of the SMA, that is not even a starting point, and nobody's going to do that. Not that you can do it by legislation. So that is the nature of the. This is very peculiar with this case, so we have to keep on, changing the strategies. We were for a minimalist approach, but not so minimalist, again, as to say only that I recognize by a declaration of the Supreme Court cohabitation of same-sex. That would be a perfect us.
But it would only be a Pyrrhic victory if there were no consequences. I mean, I absolutely get the point that if you're looking at this through the constitutional eyeglass, then nothing less than full equality is important. It is, and you pick up on Rob's point that I think a couple, this guy Dan Mendoza, 2001.
House of Lords, 2004.
2004, so the civil partnership
Was on the way.
On the way.
Yeah.
And picking up on, your point, Dr. Singhvi, about the courts, even so brave a court as the Supreme Court of India, just seeing and picking up on labour where the waves are coming. If you have to, and I hope you don't have to, but if you have to recall, thinking about something with consequences, which then shows people, as it did in this country, that hey, same-sex couples are actually the same. Anyway, that's advice from people who haven't had to argue before the Supreme Court for 10 days or more, you said. Do you have any other questions? So if you just start by saying,
Hi, my name is Jet Omat. I teach here at City Law School, Human Rights in the UK and International Human Rights Law. And one of the topics that's quite common for students, especially with those from India or background in India, is they want to look at India's law and whether it's in conformity with international human rights law, looking at some convention and looking at whether Indian law in equality of men and women or violence against women or children and so on is conformed to international human rights law. And you mentioned your arguments being based on referring to UK law or the US law and so on. Just wondering whether and to what extent regional and international human rights law might come into play in any of your arguments. We've heard the ECHR be mentioned, but also the Inter-American Court has dealt with this topic. That's one, just if I can also get pick your thoughts, whether or not you ever see the opposite direction happening, that other courts are looking at the Supreme Court of India, which you mentioned being superpower in judicial review and everything, whether or not other courts around the world are maybe looking at what engagement. And that's a third question.
The second part of the question is considered shorter. Depending on the nature of the issue, courts have the opinion in Supreme Court. For example, the basic structure there, we now copy in 5-6 countries around the world. So it depends very much on the nature. Okay, but there will be a lot of areas where it is not being planned. But on the first part of the question, we have a specific article in the Constitution, and we have any number of judgments which say that international treaties to which India is a party are an aid to interpretation, statutory law, point number one. So whenever an Indian statute is interpreted, if there are two possible interpretations, the one which is far compliant with the international obligation of it, as a matter of Indian law. Second, as you know, in India, unlike the US, treaties are not self-executory. They're like a British system. the international commitment has to be translated into the domestic law. I believe in US, mostly treaties are self-executory. So ultimately what matters is the Indian statute. And the Indian statute is saying X. We interpret it to the hilt in compliance with India's covenant obligations. We have many international treaties. The international covenant, so they're not obviously in the human rights, visual treaties, but for the other international treaties we are talking. Would be interpreted even to a limit, beyond stretching it. But suppose the Indian statute clearly violated the international, then they would make that observation. The judgments would say that this is wrong, Indian law shouldn't change. It is not what our hands above. If they can't stretch, normally they stretch the interpretation to make it from that. But if they can't, they say that, and then it's left to the legislation. So treaties are very much part of the system. As far as citing of case law is concerned, in a matter like this, it is like with us language, wherever light comes from and the comes from, it's open. There is no insularity or dogmatic about it, because if there's an appropriate direct case from the ECHF or from the American Commercial Rights, we will cite it on the declaration. I mean, there were other foreign cases, which have not decided. We did cite a lot of foreign cases here and there. And had there been something directly cited, because they were really at first principle, they were deciding it at first principle. They depend on what Supreme Court faith was pursued to adopt. And India is, in that sense, much more open and welcoming of foreign judgments, with one caveat. Now we have such a rich knowledge in schools in 75 years that the case must be on point for a gap. It is not normal. There is something directly there. It's obviously not. But where there are gaps like this one, if foreign judgment waves.
I just want to add one point that there was a recent study about this. There have been some 43 countries in the world which have cited since 2009 over 125 cases decided by the Indian Supreme Court, over 500 plus citations. Interestingly, the Inter-American Court on Human Rights or the Human Rights Committee and those international human rights machinery, those institutions have not that much cited, but national courts of these countries have, and they largely, to a large extent, belong to South Asia and Africa, and to some extent, Middle East as well.
Well, I can't help but react to your question about the accusers. Michael Wilson, I just retired from the Supreme Court of Hawaii. So in the United States now, we have a bit of a rift between the federal courts and the state courts in terms of the degree to which it's useful or proper to refer to foreign jurisdiction. And I was saying this because I think it does depend on the area of the law you're discussing. We have an area of the law that's quite controversial in the United States now, and globally it's getting a lot of attention having to do with climate rights. And since our federal judges are so unhelpful on that issue, it has caused state judges such as ours to reach out to, for example, cite he and his Supreme Court. And we have been affected by the analysis of the Supreme Court in terms of their interpretation of the right to a clean health environment, and that being a right that is subsumed under the right to life in the Indian Constitution. I am interested from the point of view of a successful decision of the Supreme Court, what your thoughts are about, given the kind of robust opposition you have, your thoughts about an effort to try to amend the Marriage Act and make it clear that it actually does apply to same-sex.
Very clear, frank answer to the question. There's a lot of resonance, there's a lot of movement, there's a lot of understanding and recognition, even in a traditional, supposedly traditional site like India, about this category, and if they are under disadvantage. But to give you a frank answer, I would say never, irrespective of government orientation. I'm not talking, was this government or forms of this government, never. But even other governments, to legislate same-sex marriage, I find.
Well, I meant to clarify that this statute is meant to prohibit same-sex marriage.
Oh, the
Possibility that you have a legate. I mean, where of the case? I'm sorry.
I misunderstood. Well, this government could do it. In a recent judgment, which I have succeeded in hardly a month ago, of course, not having emotive social issue, but in a highly politically charged judgment, which is the turf war between the central government and the Delhi government, NCT. We won a complete judgment in favor of the NCT by the same five judgment, the same one.
You may want to explain that for the NCT.
There is, as you know, we have central government, the dark country, and we have the national capital of Delhi, the national capital territory of Delhi, which not quite like Washington D.C. It is a special status, so it's neither fish nor fowl. So there are states of the Indian Union, there are union territories, and then there is a third special category in the zone of Delhi, which is not a regular state and not a regulated. So it is a state for all practical purposes with an assembly and elections, but with three constitutionally excluded subjects, which are reserved for the central government: law and order, public order, land, etc. Otherwise, for practical purposes, the white part of the state. Now, this government is particular at the center, and this government in NCT by a party called AAP, the AAP party. There have been huge wars, and ironically, although the Congress is opposed to the AAP at other levels, I am the main counsel for the AAP in Supreme Court. So, this was a month ago, a second fine judgment, which laid down the exact demarcation of power between the two and settled a lot of the doubt. Very, very well written, comprehensive, and we won most of the rights we wanted, saying that except for these three excluded subjects, you can't pour those into every damn thing which happens every day here and can't adjust it. Within a week of that, it passed worse than what Mike said. The ordinance, not yet enacted, was the next session of Parliament, is the monsoon session in July. This judgment happened a week before the conclusion of the term on the 10th of 8th of May, and 12th of May, and 18th of May we closed court. On the 18th of the day of closure of court, they passed an ordinance reversing that judgment, which is permissible, they didn't know, but it is testable. No judgment can say, I reverse A versus B. Sorry, no legislation can say, I reverse A versus B. They can only legislate to remove the basis of the underlying principles on which that judgment is based. And if you successfully remove those principles and substrate them, then in a subsequent challenge, the court will decide that automatically a judgment is followed. But they've done that in a very highly surcharged. This one is socially, emotionally surcharged. That was politically. So I would not put it beyond them to do that. But I don't think we are in the same situation. I don't think we are going to have such a thumping victory. We're very happy with the middle level victory. And the middle level victory may not lead to a legislative reversal in the same way. But if it's a full-blown victory, that I would agree with it.
Well, hi, Jeffrey Thompson, I teach here. I would have expected that in response to cases like what we've been discussing, the government would be pressing to pack the Supreme Court with conservative justices. Is that happening?
Well, that's what they'd love to do.
Yeah.
But unfortunately, the power of appointment is with the judges. So it's not easy, but what they can do, I mean, it's not so simple. The ultimate power of appointment of High Court and Supreme Court judges is with what we call a collegiate, which is basically a panel of senior judges, Supreme Court. 5 in one case and 3 in the other case. Now, clearly, you don't have the last word at the government to appoint me. But you have the power of delay, you have the power of obstruction, you have the power of bargaining. So I propose, as the collegiate, Mike Wilson at the appointment. She, as the government, cannot oppose directly at saying, sir, my Vincent appoint so and so. But she, as the government, can delay my Vincent's appointment so long as to either cost him his seniority if he's appointed after 6 months, or to just, making very difficult to withdraw and then resign. Not resign, withdraw his name from the parties. Or more frequently, make the Supreme Court regime so mad at the rising vacancy, they'll say, okay, we need to worry two of yours, we will follow us. So this is the problem. So by and large, the collegium prevails, but there are a lot of ways in which that can be managed or changed or died into.
Notice that longer the government stays in power, the more.
But one of the biggest wars going on at the moment is a full majority government after almost 30 years. There's been no full majority government in India for 30 years. So full majority government is having a huge tough war because they want to control all of it. And the biggest factor is to control the judicial order. One of the ways is disappointments, but there are many more ways. Transfers or sending a message. There's certainly, it's not easy to say in public that we hate.
Well, so something that is troubling constitutional courts worldwide, UK, Poland, states all around the world, is the political ecology, if you like, of the institution. So we touched just now on the politics of the judges themselves, with respect to the politics of the judiciary, but there's also the political legitimacy of the Supreme Court as one of the central institutions of the state. With a very activist Supreme Court, as in India, and a very politically powerful government, how is the legitimacy of the Supreme Court with, as it were, the public at the moment? How do you see that going?
Right. Lots of that's not a question, and partly what I'm addressing in other lectures, but it's a very interesting question. Briefly stated, the answer to your question is that there is no doubt that despite the vicissitudes to take a overall view of 75 years of Indian democracy, there are ups and downs, there's an emergency, there's the good judges, bad judges, good decision, bad decision, all kinds of phases. But partly straightly, I think mostly not straightly, there is absolutely no doubt that at no point of 75 years has the judiciary been not the most trusted organ of state. So it was triple negatives. Basically, the judiciary has remained the most trusted organ of state entire 75 years about that point. B, that is not so much because you are so good and virtuous. It's because we and her are much lower down. We being the executive, she being the legislation. So it's really a relative thing. And relatively, the executive has been viewed with much greater distrust. The legislature has, in the British system, much more than Great Britain, has become controlled by the executive, because the executive is a subset of the legislature in the British system which you adopt. And unlike the American system, the legislature, most of the command of the executive, which is indirect. So, therefore, it is by relativism and comparison that they have regained the post of public. Third, that has meant that some of the excesses of the Supreme, there have been many, are much more readily condoned and much more readily accepted. Number four, it means that actually the Supreme Court becomes more reasonable. See, being overactivist can also be trespassing, can also be wrong. Indians consider that it's too less of trespass, too more. So the court is not criticized for the excesses. It is criticized for not doing enough excess. And fifthly, therefore, when there is a certain ambience of hesitation and fear, as there is now, this is not very fashionable to say so, I'm sure, You go back home, might write articles saying I'm criticizing Indian judiciary on soil. But there is no overt attack on the judiciary. India is an independent country, but messages are sent by overt indirect tactics, which is why the people feel that this most trusted over should not be added. So one is delay appointments. Second is transfer sometimes. In the process of bargaining, you end up punishing the more independent auditing judge. Sending a clear message that, look, see, 90% of cases are normal cases. Push comes to shove, is only 5% that case. In those cases, if you show too much independence, then, we are watching, Big Brother is watching. So that kind of message gets that. And that, I think, is the real issue. Courts are standing up to it. The public wants them to stand up, but sorrow is happening. Because ultimately, courts are based on individual judge.
Do you think part of the reason, sorry, I'm too interested in it, I'm abusing the chair's position. Do you think part of the reason is that the Supreme Court has made itself an approachable rather than a remote court with, the much cited, because it's another postcard, the use of public interest litigation?
I said, there's been a long move for many decades in India to make the Supreme Court a constitutional court. I'm asking you a question from another part. Why should the Supreme Court be muddied its hands with pedestrian matters? Why should we be dealing with landlocked and discipline? Why should we be dealing with a check bouncing appeal? And this not America that. This has been a debate for almost 3 decades. But the Supreme Court of India has a dual role, like a multiple role. It is a pedestrian court with more normal matters. Exactly what a first court of trial court would, but it is an appellate set. And it is also a high court of constitutional jurisprudence. I have now come around to the view that, a pendency of 50,000 matters sounds a lot to you, but in India it's nothing. It's nothing. A pendency of 50,000 matters with 35 judges. Actually, it is because it does a large bunch of those non-abstract constitutional question matters that this trust and paper stuff. Because it is a court of last resort for the despised, the dispirited, the disappointed, the disgruntled. They have that fate. And the moment the court became that unreachable abstract institution, the fate will decrease. My own, and it's begun emanated. The court has origin is the Schlossen's ambition. It is mostly it has this nice system of leave to appeal, so that it's not you don't enter the house straight away. You leave to appeal. The process takes time. But I think it's a much better way to keep it as a common man's court. Also. I think my name is Idris Andin Masters here. I think you've spoken about here. You've spoken about the trust of the Indian judiciary and how it has the people's court and everything. But in the past couple of years, maybe because I have recently started noticing, there's been question on Supreme Court with regard to appointment of Mr. Kripal as judge. For example, the Jangipuri matter when the Chief Justice himself ordered there's not supposed to be removal of encroachment, but the smallest civic authority and the order city to not to comply with the orders. And so many of it, like in the CA challenge case where the Supreme Court has chosen not to state the applicability of the act. In those years, do you see that all this trust of 75 years somehow is being tarnished or some going in the other direction? See, let me answer the question differently. Individual cases they can go on and on. There are lots and lots of such individuals. Call them aberrations, call them disappointment. Certainly there. But institutionally, by and large, the answer to your question lies in the fact that the threats to any judicial institution, certainly in India, is much more from within than from without. There is a threat within are the aberrations which you mentioned. So there are judges who have a poor track record. There are judges who have come from the background where they have acquired a certain religious or philosophical mindset. There are judges who cannot rise above that person. And if those, that's why the selection process is vital. And the Supreme Court, largely it is being maintained by the religion. Just kept the part and said. But still, a lot of fish slip by. So these aberrations are occurring in those categories. And that's something which has to be guarded. But yes, it has remained an aberration. It's a relatively a big exception, not a rule, partly. But the more you are lax about that process of the question, then this will happen.
Like I'm Sharan Pradhan, in my LLM from Korean University. I would like to get you back to the case because I was following the arguments when we were on Supreme Court, and the bench at one point would put a question to the respondents whether any person in India has a fundamental right to life. I would like to get your views on it because I believe you did not get to respond to that thing before.
Well, that is part of the dialectics of the answer question last. The answer from our side was absolutely verbatim, and it was sourced and premised upon diverse parts of Part 3 in the Constitution, including right to dignity, Article 20 of right to life, freedom to express and manifest to ourselves, etc. So we have certainly claimed that. But we've gone ahead and said that right to marry is itself vital as the recognition of a social institution. We want to be married couple. We don't want to be cohabiting couple. Or what the court says, we don't know. That's certainly. But there has been the next point that we don't want it to be a hollow, empty label or somewhat. That's the two parts. There are enough sources with Part 3 articles to make that point in case they decide to accept this one, but it's foreign to Article to Part 3.
Because the bench, agrees that there is a fundamental right to marry, then all the subsequent attached rights to marriage, institution of marriage, all.
But our argument is not based only on the fundamental right to marry. We said that assuming that there is no fundamental right. That's one part of the argument, but obviously you pitch it high. The next level is that in any case, the discriminatory exclusion of certain categories from the institution of marriage is by itself bad because of discrimination. So that's key. You don't need a fundamental right argument to succeed to make our case. Indeed.
Got just a technical question about the Special Marriages Act. So if you win your case, will same religion, same-sex couples be allowed to marry, so to be induced to Muslims, etc.? They will be constrained.
All categories, if we win the case, is just form of this degree. All couples who choose to marry under the SM. The whole thing, let's forget this case. Right in this case also, the SMA was a special platform created for couples of different religions to marry. That is the purpose of this heterosexual couple. That is the whole purpose. So now all that we're saying is that what platform we are giving as a religion-neutral platform to heterosexual couples should now also be allowed to be used as a gender-neutral and sexual orientation-neutral platform for people to marry. And if they choose to marry, just like for heterosexual couples, the religion is irrelevant. It should be relevant for same-sex couples also.
So any opposite-sex couple in India will can choose
to marry under the other special law. Which is go for registered marriage. That is why the whole argument of the just by interpretation just use spouse or person. That's the whole. Because the moment you marry outside the SMA, you cannot.
Any other questions?
We all know who the people are who rush in wearing to a stirred tread. So let me put myself in that category.
a lot of the academic commentary on same-sex relations in India makes the point that, from the point of view of legal history, this has its origins in a British colonial imposition. Absolutely. And so, looking outside in, something that I find difficult to understand about the series of government positions is that, other things being equal, one might expect them to be in favour of removing British colonial imposition. And yet, this seems not to be the line. So can you explain this?
I certainly cannot. It's a subject of research, but simple answer to that is that 300 years of colonial history does leave a lot of things. So a lot of things have been engraved. There is no doubt that Victorian morality of the kind which spread at certain phases in India is not an original Indian concept, but then one of the great strong arguments against colonialism has been that you have succeeded in changing the mindset. That's a fact of life. And that's a great achievement in the British, in a negative sense of that. And Sashi Tharoor's over strong book makes that point that way. Partly, it is the greater, your question is very interesting and ironic. The greater irony is, taking your question further, that's a remarkable irony actually, struck me after you asked the question. This government hates everything which the British imposed. They actually detest everything which the British imposed, or at least anti-preserve what they imposed. And they speak about it every day. But now somehow this part of the sex part has got so offended that they support it. However, having said that, I would not go that far as saying it's only the British. See, what you are talking about is Indian morality of the ancient ages. There's a difference. Now let's be really balanced about handling the British entire. The ancient India had a diversity of morals, a very good kind. Medieval India had half of that. And then came Mughal India. So it already started dying. So the trend was towards the British direction. And you solidified it by a certain provisions and the Mahometan legislation. So it's fair to say that there has been a diminution of the liberalism of ancient India, which I would say broadly in that glowing degree ended in the first, second, third century, the BC period, Maurya, and then the post-modern Gupta period. Those were the great flowering of culture, Renaissance, our Khajuraho, freedom of all kinds of sexual acts, etc. That was already declining pretty much for the last many hundred years. So the British are not only to blame.
But there's another explanation to it, which is that it is not uncommon for politicians and politics to pick up what is convenient and acceptable to. This is, in fact, the flag legislation is a good example. One would think that that was part of a colonial era whereby the Indian or the flag was expected to be used by those who are only in power. And one would think that in 1947, when we got independence, the first thing ought to have been done is to remove that. But those who were in power felt equally comfortable that so long as it can be used by those who are in power, it doesn't matter which flag is flying, but I get to use it. It continued till this case which our Chancellor Naveen Jindal fought against. So in a way, governments, when they choose to do what they do, it need not necessarily be, they don't ask the question who did it, but they're comfortable to take it, whatever suits them.
Even in the most liberal of ancient India, same-sex marriage was not happening. All that was there was that individual examples were looked at differently. So, you can't really say that something which was entrenched in India is being excluded. There was a real amount of liberalism for all forms of expression. But here, it's recognition as an institution of marriage. So that I think with a conservative government, it would be impossible. Even the non-conservative government, they just stay for the optics. So they won't want to take it on themselves. At the most, they will say it's okay if you fire it and from your shoulder. We'll be silent, but we will not say it. That would be the highest degree of, yes, they will be second.
Well,
As we go on and bit into culture, let's start mentioning 2009, I was speaking with law students at NUJS in Kolkata about same-sex marriage, and they told me that already love marriage with an opposite-sex couple was controversial in India. Forget about same-sex marriage. So the idea that your parents choose your spouses, I'm sure that was part of the context. But that is, I'd like to link this to a point about I just made it recently. I saw a film called the Blue Kaftan about a gay man in Morocco, like artist from Libya, and he thinks the Arab world is hopeless and it's not going to change in 200 years or whatever. And I said to him, well, films change before the law. Then I pointed to my beautiful Laundrette and another country called in the 1980s in working. And Bollywood gives me great hope in India. In particular, the film Bate Badayo, I did last year.
Beautiful comedy in the
Hadaistic little right Delhi, right, as a police officer. It's a gay police officer. It's the
Other movies.
Sorry?
There were two movies. One is about same-sex marriage and other is about middle-aged women.
Okay, it's the same-sex marriage, but it's a gay police officer meets a lesbian woman during his work and proposes a marriage of convenience to please the parents. And it's very well done, and in the end, lots of tears and understanding, and so it's that kind of thing that I had not more.
You're right, absolutely. These are things. They've been earlier aggressive. Bollywood has been much more. No, I think that's absolutely true. And the first part I want to say, it's not anymore a traditional society in terms of choice of life. We have arranged marriages, which is an anathema in the West. So arranged marriages is sometimes understood here to be that we do not have the choice of marriage. Actually, the arranged marriage form is equally free. Both parents kind of suggest spouses. In most, of course, there is a certain class of people where it's tyrannical the way to do it. But now, in most of India, I would call most of India now rural India, not rural, and so much is rural. And in most of rural India, except in individual cases, the highest level of income, you would still have tyranny, though you shall marry souls. In the lowest level of income, very poor, you have freedom. So barring those individual eccentricities, marriage is very free. People common. Love marriage is very common. Arranged marriage is also, in 90% cases where there is not that tyranny, there is a suggestion, and there are platforms and facilitations for meeting. But they're up to the choice, and you do that 10 times before you meet the level of partner in marriage. So therefore, it's not that the same sex stands at a politically different area. There is a mental block. There's no doubt there's a mental block which is not there for love marriage, not there for normality.
Like how many dating app, but they have for your parents and they're free.
There are so many dating apps all over India, and they're so fun, they're very common.